Thank you very much, Mr Chair, for the opportunity to speak to Part 3 of the Family Court Proceedings Reform Bill. Mr Chair, I do want to point straight to Clause 60A, which sets out the duties of the family dispute resolution providers. And in Part 2 of 60A, it says that in A, the FDRs must identify the matters at issue between the parties, facilitate discussion between the parties in respect of those matters, and C, finally, assist the parties to reach an agreement on the resolution of those matters that best serves the welfare and best interests of all children involved in the dispute. Now, Mr Chair, on the face of that, you can't have too much problems with them, but as always, the devil is in the detail with the National Party. To get to an FDR, you have to pay, as Mr Goff says, $897. Now, Mr Chair, that is going to be very restrictive to many families, certainly a lot in my constituency of Mana, and I just wanted to commend a number of the family law specialist lawyers who came to me almost instantly when they found out that this piece of legislation was going to be introduced to this House because of their concern around the access to justice for families who could not afford it. They believe that this fee of close to $900, Mr Chair, to go through this family dispute resolution will be prohibitive for many families in Porirua, will cause a lot of families who cannot afford to go through an FDR to actually have more problems between those two parties. Because the issue being, if you can't afford to go through an FDR, that the issues between those two parties will be left to fester, and that things between those two parties could actually get worse. They did point out that their system that is currently in place gave families or the two parties the ability to go to 6 court-funded counselling sessions. And that was very, very valuable to those parties in making sure that they could hopefully come to some agreement before you get to the serious stage of negotiations around a separation. But as Phil Goff mentioned in his speech, it's not necessarily that this government wants to help families that are separating by introducing this piece of legislation. They're actually looking at cutting costs within the court system to make sure that it can meet its needs. Now, to look at some of the things that some of the savings that the government will find by moving to these FDRs and changing the system within the family court proceedings, you'd only have to go to the regulatory impact statement, where it does quantify some of the savings that will come about by introducing the FDRs. On page 9 of the RIS, one of the options that the court looks at is repealing the existing obligations and replacing it with a focus on the court carrying out its primary function in a way that produces the best outcomes for children and vulnerable people. This is a recommended option from the advisors who put the RIS together, and it's revealed in that document that this will create a saving of close to $10 million based on the 2010 and 2011 expenditure for all cost-funded counselling. Now, Mr Chair, that is in black and white the real motivation of what these changes are. Now, as it says in 60A, the FDRs may be being introduced for what would seem a good purpose. But the real motivation for setting up the Family Disputes Resolution Service is to cut costs. Another measure that will save costs that is pointed out in the RIS is to limit the number of those counselling sessions that I mentioned before, which currently is 6 at 6, to, it says here, an option of 1 or 3, and that, Mr Chair, will save up to $4 million based on current expenditure over the next 2 years. Mr Chair, we're very concerned about this Family Dispute Resolution Service and the cost that it has set up, because it does create a situation where the have-nots cannot access a fair justice system when it comes to resolving family disputes. They cannot do that. And Mr Chair, that was a concern that was also held by the Law Society. A society that it seems this government doesn't seem to care about the opinion of anymore, because of a lot of pieces of legislation have been through the House, and the Law Society has given their frank opinions on that legislation, but this government seems to hell-bent on ignoring it. Mr Chair, in a submission made on this bill, or I think when this bill was introduced, Mr Chair?
Chris Farfoy.
In a submission that the Law Society made when this piece of legislation was introduced, it had two very big pieces of major concerns when it came to the Family Dispute Resolution Service. And if I can, Mr Chair, just read from its submission. Firstly, and this I'm quoting here now, firstly, imposing a large fee puts a big barrier in front of those who want to resolve issues that they are unable to resolve themselves. Access to justice is a fundamental mark of democratic and fair society. That access will be impeded in New Zealand by this fee. So, Mr Chair, we do have the Law Society very concerned, along with the Labour Party, that this fee will restrict the access to justice of a lot of families who are not only going through financial hardship, but going through very tough times within their own families themselves. The second concern that they had, and again quoting, requiring the parties to split the fee provides one party with the power to delay matters, control or even prevent the process by refusing to pay their half. The FDR needs to be encouraged. Its strength is an early negotiated settlement, but giving one party the ability to stifle the process by simply refusing to pay the fee is to deny the other the opportunity of resolving matters in a timely and child-focused way. So, Mr Chair, the fee that you need to pay to access the family disputes resolution could actually be used as something against one party in a dispute with a family. Now, Mr Chair, I think maybe I would like to hear from the Minister about that concern that this Law Society has, and certainly if this could have an effect of making things worse within families. And I know certainly that the local family lawyers in my area have concerns over that, because they are going to be in plenty of situations where families will be accessing this, and as I said in a previous debate on another part of this legislation, where there is financial abuse going on in a situation, this is concern from the Law Society could certainly come to fruition. Mr Chair, I do want to note some of the ardent opposition in Porirua to this. Catriona Doyle, a family lawyer in Porirua, moved very quickly to make sure that the Law Society locally and nationally spoke out very strongly against the changes that are in this bill, because it will restrict access to justice for families who cannot afford to access justice. And we don't believe that is a good thing. As Mr Goff said, it's fine for people who can afford it, but it certainly does hamper the process for families who are not in a financial position to be able to access justice and the Family Disputes Resolution Service. Mr Chair, on the face of it, 60A points out some very good things that the Family Disputes Resolution sets out to do. But, Mr Chair, this government isn't really after in this legislation to make things easier for families who cannot afford to access justice. At the moment, they can do, and it's cheap or free, and they do have the access to 6 free counselling sessions. But, Mr Chair, under this legislation, it makes access to justice much, much harder. It imposes a close to $900 fee on those families who want to enter into the FDR. And, Mr Chair, it's my submission, and I'd like to hear from the Minister and the Chair, and it's also a submission from the Law Society, that the fee to enter the FDR process could actually be making things worse for families, not better.
Scott Simpson.
I move that the question be now put.
Dr. Rajan Prasad.
Thank you, Mr Chairman. It's pleased to take a short call on this part of the